Okay, and the page number again is what?
C204. Interrogatory response 23.
Okay. $23. Okay. Go ahead with your next question.
Thank you. And Jamie, after your employer proposed group sex with you and your high school friend, how did you reply?
No. We both replied no.
Okay. And was he working at the time?
I don't recall if he was actually working or not because this conversation happened. He was out behind the bar or from in front of the bar. He wasn't behind it. So I don't know if he was actually working.
Okay, thank you. And Sandy, when was this?
That would have been, yeah, in December of sometime.
December 2017. Is that correct?
Yes.
Thank you. And Jamie, another incident that you referenced in your complaint, which is Exhibit 1. EOD C003 occurred in January of 2018. Can you tell us what happened then?
Yes, that would have been a night that I was closing down the kitchen. And I would say it would have been roughly like 9:30, 10 o'clock. I remember the time because I was just finishing up sweeping. Chris had came in and asked me if Audrey was working. I told him I wasn't sure. He had went to look for Audrey and came back and said that she had already gone home. He said he needed a ride to his friend's house to pick up a money bag and asked if I had been drinking. And I replied no. And I told him that I was still cleaning the kitchen, and he said that that's okay, that I could do it when we got back. I also told him that my truck wasn't very reliable, so he said that we could take his truck. We then proceeded to get in his truck, him and the passenger. Where we drove to, I don't remember the road, but I remember exactly where it's at. It was right down the street from Izzy's, approximately maybe 3 or 4 minutes. We proceeded to go and get the money bag. I pulled into the driveway. I think there was some event or something going on that day because he wasn't at work. He had like came to work and then had to go back for the money bag. But I could hear kids that were outside running around. And so I waited for him in his truck for maybe, I don't know, 3, 4, possibly 5 minutes. He came back with the money bag and then we proceeded to leave. It was on this back road that leads to Izzy's. He had pulled out his penis, and I will never forget this because he had actually said to me, "Look how little it is," and then continued to say, "Don't you want to just touch it, put it in your mouth?" And I immediately started laughing and said, "No, like it's not going to happen." He continued to play with himself and say the same things about me touching it. And I had pulled into Izzy's and continued to tell him no. And then I got out of the truck and went inside. I don't know if at this time his penis was still out or not. I walked into the bar and ran into Izzy, who is Aisha's mom, who said to me, "Where's Chris? Did he get the money bag?" I said, "He got the money bag. He's still in the truck." I then went to the kitchen and cleaned and ended up going home.
Why did Mr. Jecevicus ask you to give him a ride?
He had been drinking. He was intoxicated.
Why did you laugh?
Because it was a funny thing to hear him say, and it was, I don't know, maybe I think I laugh when I'm nervous.
And did you tell anyone about the incident?
I did. I had told my aunt about it, who was the one who introduced us. I actually had to get a ride from her because my truck not working. I think it was either the next day or the day after, and had told her what had happened. And she had went on to tell me that apparently Chris pulls his penis out all the time in the bar. It's not the first time. I also went on to talk to Audrey about it, who was a waitress there.
Was there a person that you felt you could have reported it to, who had any authority or power to do something about it?
Not really.
If you wanted to report this, would you have had to report it to Mrs. Jecevicus?
I mean, I would have, if I would have felt that she would have taken it seriously or believed me, then I obviously would have reported it to her. But at this time, I mean, my relationship with Aisha was never very close. I had tried to befriend her, but it just never really happened.
Jimmy, I want to talk about March 27th of 2018. Which was, in your submissions, your final day of employment.
Yes.
Were you scheduled to work that day?
Yes.
What shift were you scheduled to work?
I believe it would have been noon to close.
Was it a dishes day or a cooking day?
It was a cooking day.
Did you work that shift?
No.
And why not?
I had went in for my shift, but then I ended up leaving.
What happened when you went into your shift?
I had an argument with, I think it was Paco, I believe. And I had already been text messaging with Chris about being paid, in which he wasn't paying me again. And I believe that something may have been said between me and Paco, or he possibly sent me home. I don't know. From what I recall, I was really upset and I walked out and left.
Did Paco send you home?
I know that he sent me home. I don't remember if it was on this day or if it was a previous day to that day.
Okay. Were you intending to quit that position?
No.
Okay. Please turn to Exhibit 4. Oh.
Do you know what number?
Give the bait set number.
Okay, just one moment. Just one moment, I'm sorry. ERD C165. Let me know when you're there.
I am there.
Okay. You texted your employer, "So I'm fired, huh?" You see that?
Yes.
Okay. Why did you believe you were fired?
Yes, because that would have been, Paco sent me home.
He sent you home from your shift. Did you believe that you were fired?
Yeah.
Okay.
I believe Paco had said something to me about that they didn't need me or he didn't want me there.
And if you look, Mr. Jecevicus' response was, "Did you really just ask my father-in-law to pay you or tell him you needed money?"
Yes.
Can you tell us about that interaction?
Yes, that would have been Aisha's dad, and I didn't ask him to pay me. Chris and Aisha were on vacation. What I had asked him was if he thought it would be okay for me to ask Chris to be paid while they were on vacation.
And this was on a Tuesday?
Yes.
Okay. Were you contacted by Mr. or Mr. Jecevicus after after the cook sent you home?
Yes.
Okay. Please describe your contact with Aisha.
I think they both had contacted me to see if I had just left and were asking about it. And I was incredibly upset at this time. At that point, at that day, it was kind of all I could really take. I had kind of reached my limit with everything going on. I had then went on to tell Aisha about Chris pulling his penis out, and I had confronted Chris as well about him pulling his penis out.
Okay, Jamie, I want to talk about each separate interaction.
Okay.
Did Mrs. Jecevicus contact you by phone or text message?
We actually had a phone conversation.
Okay. During that phone conversation, did you tell her about Mr. Jecevicus exposing his penis to you?
I did.
Okay. And what was her response?
Her response to me was, "I've dealt with women like you before."
Did she tell you that she would investigate the matter?
No, she was incredibly rude about it. From her telling me that she dealt with women like me before had made me feel like I really didn't understand it. She was angry and upset with me about it.
Did she tell you that she would talk to Mr. Jecevicus?
No, I believe it was a pretty heated argument that we had had, and either she hung up on me or it was disconnected.
Did she ask you for any details about the incident?
No.
Okay, and how did that phone conversation end?
On a bad note, obviously, like I said, I think she either hung up on me. I know that she had said to me that she was on vacation, and she had said, "I'll deal with all this when I get back." I don't know if that meant dealing with what I had told her about Chris, or if that meant me walking out that day. I couldn't tell you what she had exactly meant by that.
Okay. Did she give you any indication that she would follow up on the allegation or the report of attempted sexual assault?
No, I didn't feel that she was taking me seriously at all, or that she even cared about what I was saying or how I felt.
Okay. And then let's turn to your conversations with Mr. Jecevicus that day. As you recall, on ERD C-165.
Yes.
If you could just read along with me. You had asked if you were fired.
Yes.
He responded with a question about whether or not you had asked to be paid?
Yep.
Okay. Please turn to ERD 167. Would you please read, do you see your message, the first one at the top? That starts, I have a ticket to pay today?
Yes.
Would you
Yes.
read from that, just that whole message? What you said?
Just,
I have a
it's in the record, you know, that her reading it, she can read it to herself, but just please ask it because reading it doesn't help the record any.
Okay, thank you, Your Honor. Excuse me, I dropped things off my desk. Okay, on ERD 168, you said, never have I ever felt so disrespected,
Yes.
and I do not deserve to be treated like this. What were you referring to?
All of it. I was never paid on time. I came in early and stayed later. It was never anything good enough. There was a promise when I had got hired about getting a pay bump and how if I did these extra things that I would get that. I never got that. After him pulling his penis out and after the meeting with between me and him and the cooks and the HR comment he had made to me, I felt completely belittled and very disrespected.
Okay, and please turn to the next page, 169.
Yes.
Where Mr. Jecevicus says that you have done nothing but disrespect them since day one. Your response is, really, I'm not the one who pulled out his dick, am I, Chris? And his response is, I think it's sad, actually. At any time, did Mr. Jecevicus ask what you were referring to? Or
No.
ask you to clarify?
No. He knew exactly what I was talking about.
Okay. And you would turn to ERD 180, C 183. Please. Let me know when you're there.
I am there.
Okay, thank you. You had said, I appreciate you giving me the opportunity. I just don't like being talked down to or sexually harassed or disrespected. Didn't interrupt y'all vacation. Just really wanted to get paid on time. More than that, needed to.
Yes.
Was that you intending to quit?
No.
Did you feel, oh, go ahead.
Go ahead. No, go ahead.
Did you feel like you could return to the workplace after this conversation?
I feel that if anything would have been taken seriously or they had tried to even make things any better, I feel I would have went back to work. We could have made it work. I very much wanted to make it work with them.
Did you have any indication from your conversations on March 27th with either Mr. or Mrs. Jecevicus that they were going to take your allegations of harassment, attempted assault, and disrespect seriously?
No, because in the previous meeting I had had with Chris and the cooks, I was shut down at that time. Also, I had a meeting with Aisha to try and resolve these matters, and nothing changed after that either. So at this point, it had really felt, I mean, if they hadn't done anything up until this point, what were they going to do then? How were they going to make it all any better or change any of it?
And did Mr. or Mrs. Jecevicus ever contact you after that day to confirm you were not returning?
No, not that I recall, no.
Okay. Those are all the questions I have for the complainant.
Okay, well, I just would notice that, and I would at some point, well, actually, I'm dealing with asking right now. When I'm hearing this testimony and I'm trying to clarify as to what the claims are in the situation, that it sounds as though that initially that you're claiming a termination, but then you're claiming a constructive discharge. You can't argue the facts in the alternative. Are you claiming that the employment ended because that she was believed that she was discharged, or that at the real end of her employment that she didn't come back to work because it was, if they weren't taking her seriously, that it was so intolerable that a reasonable person would have felt compelled to resign? Or do you want to have, my understanding is that you can claim that, you can't claim facts in the alternative. So, you know, it's either as far as your claim going forward that her employment ended because she believed her was terminated, or it is at a certain point that she viewed that she couldn't go back because of her treatment. You understand my question?
I believe I understand your question, Your Honor. I understand that you've said we cannot argue the facts in the alternative. Sometimes, as you know, life and legal theories don't match. Certainly, I believe we're arguing that both of those things did happen. Legally, we are arguing constructive discharge.
Okay,
she was told to leave. She did believe that she was terminated, and when she tried to confirm that with either of her employers, they made it clear that it was that they were not going to allow her to return to a healthy or respectful.
Okay, so my understanding is that you are, as I sort of understand that, that in your claim there's a two-stage thing. That initially that she believed that she was terminated, and then there was the discussion, and after discussion that she viewed that she was constructively discharged because, I mean, you are talking 2 points in time, my understanding.
Yes, Your Honor.
And so that my understanding that isn't talking, if you are talking at different points of time, then it is not arguing facts in the alternative. It's saying at this point it was this, at this point it was this. Am I understanding your position?
Yes, thank you. Well said, Your Honor.
Okay. And my understanding is, Mr. Lloyd, is there, in your understanding, is there any reason legally why they cannot view that or make the argument that at different points in time that she initially believed that she was terminated, and then during this discussion, then because of the discussion that she viewed that she was constructively discharged? Is there any reason why you're claiming that is not they cannot make a claim in that manner?
As far as I can see, I'm not sure off the top of my head if there is something that they cannot do that as far as bringing that up. But from my listening to the testimony as well as reading through all the documentation, it does appear that they're trying to argue in the alternative, which is a bit surprising because as it looks to me, was she's saying that she was actually fired, but she was not.
Okay, so understanding, at least in the matter that the point at this situation is that clear what the claim is and what it is, and obviously that you can argue both, and you can argue that they're legally that this is not a claim in a situation that they can make, a situation, but at least it for briefing and other things that, is to, have it clarified that they're alleging a progression in time and initial view, and they're alleging what they're alleging, and you have the right to argue that this is facts in the alternative, or that they can't do that, or whatever. But that in dealing with the that at least we have a clear what the claim is, and obviously I believe that you dispute it. Including among the matters of the situation is that it obviously matters at what time you're talking about a constructive discharge. That because that, as I understand it, you're claiming that the end of her employment from the beginning was a quit. And so it matters whether the discharge at what point in time that there was claimed to have occurred, whether that is right at when she was leaving work, or what time it is, as to whether it was a situation so intolerable that a reasonable person would have felt compelled to resign. Obviously, so that the timing of when we're looking at the situation and the complainant state of mind, we have a legal and factual argument as looking at when she left, or was she looking at after these discussions with her supervisors? Is that, do either of you dispute that? Is that clearly, as far as the constructive discharge claim, that at what point we are looking at matters, and so that we need to, that in the findings that I will have to look at with the variations as to, at what point we are looking at. Is that disputed by either one of you, that the timing of the moment of it being claimed that we're looking at matters?
Not disputed by the claimant, Your Honor.
Dispute here.
Okay, so at least we have in the matter that we're dealing with, as far as the fact, we have a as is often the case, we don't have a single point in time where we're talking about regarding the end of the relationship. We have a series of points in time as to what exactly occurred over that time, and that we will, both in the fact and in the briefs and in my decisions, deal with that. Okay, so then why don't in the matter for other purposes, since we are about halfway, and my understanding is that you have a variety of cross, is that correct?
Yes, that's correct.
Okay,
yes.
So why don't we take 10 here, and one of the things that I will note, we have been asked that these are, just to say for your dealing with of understanding the way the recording process works and what we're trying to do with that, in case you get you want to get a recording, or whatever in this, that it took me a while to understand. What happens is this is being recorded to the cloud. Okay. What we will get is that this evening, hopefully, is notification from X on the cloud that we got the recording. Right now, if I'm going to do anything with it, then I have to download the recording so that it is able to be sent to our system. Okay. And then I need to transfer where it comes in the downloads to our place where we keep the downloads. So I'll have to save that and move it. And the reason I'm saying this and dealing with the matter, as far as what you get and what you ask for, is that means that there's a bunch of, since there's a video, there's more evidence on the situation. So I have to stop, every kind of hour and a half, 2 hours or whatever, so the file isn't too big. Okay, I'm just, you're dealing with a sort of understanding that this isn't like a normal recording where we can just go from between, because it is recorded to the cloud. So it's got to go there and then come back and stuff. So then I will stop this, and and doing the next piece. When you're asking, you will get, if you ask for copies, you will get a series of them, and probably, if this goes 2 days, you'll get 8 different recordings. Okay, warning you, because I've had to. I'm going to try to say and dealing with the matter, and I encourage you to, when we start up again, to initially say, basically day 1, part 2, this case, and so that for your benefit, that if you pull out one and start listening to it, you know which potential recordings are things that you're talking about. Because it's sort of, okay, which one next? If you just start up on the situation, you have to figure out, okay, well, where does this fit in the matter? So anyway, I hope that that's helpful as far as dealing with this. I like to sort of understand what's going on and why does it take, normally in these situations, before we would take a whole day and record the whole thing in one day, but the file gets too big and these things take a long time to record anyway. So hopefully does that help you understand the wonderful modern technology. And anyway, if you, as I said, when we're starting after a break, which we're going to take, if I don't in the matter say in dealing with the beginning of which it was in the situation, then please help me, because if you get a recording, then you may not know which order they're supposed to be in. So, okay, is that, do both of you understand what I'm saying?
Yes, Your Honor.
Sure.
Okay, take 10. Okay, this is Lamoreux CR 2018022097, part 3, day 1. And my understanding is the first thing, and how do you pronounce your last name, sir, again? I'm sorry, I'll unmute you. What?
Jecevicus.
Jecevicus. Work on, so I'll work on saying that, and you're welcome to correct me in the matter. Okay, sir, would you raise your right hand, please? Do you solemnly swear the testimony I'm about to give in this matter be the truth, whole truth, and nothing but the truth?
I do.
Okay, and this is a adverse cross, and I understand that if there are yes or no questions that you are to answer, to yes or no, and if that you want to add something, you can say, can I add something? And she can say no, and dealing with your time. And just to check, has Mr. Lloyd given you instructions as to if there are notes that you want to make or dealing with things you want to ask him about, or how to communicate with him?
I have the notes in front of me.
Okay, now I'm just dealing with if you, Mr. Lloyd, if he wants to talk with you regarding something, or dealing with things that he wants you to ask, or a situation, how are you, after his testimony, do you want a opportunity to call him? This is one of the things I'm trying to work out as far as what attorneys want.
Yeah, if I feel a need or he feels a need that we need to talk, I can just give him a call after the testimony. That's fine.
And if you want to break at that point, so that my understanding is that if there's something that you want to add or to explain, and she is saying no when it's her turn, then you can, write a note to yourself, and I will give in the matter, because, my understanding is it's a standard part of representation to be able to talk to your client in connection with their testimony. I mean, so, and my understanding is that you're not in the same place, and so that you'd have to call to do that. So if you want to have when we get through with that, if you want a break pause in order to do that, then give you the chance. Do you understand that, if it's you will likely to get a lot of yes or no questions, which nobody likes. So if you don't like them, you're normal. Okay, then Ms. Archer, then go ahead with your adverse direct.
Thank you, Your Honor. Hello, Mr. Jecevicus. Could you say your name and spell it for the record?
Chris Jecevicus, Jecevicus.
And you own Izzy's Dockside Diner, is that correct?
With my wife, I do.
With your wife. And could you tell us your wife's name?
Aisha.
Aisha. And could you spell that for the record?
AJSHE.
Thank you. How long have you owned Izzy's?
Oh, almost 10 years.
Almost 10 years. You hired Jamie Lamoreux in October 2017, is that correct?
I don't know. No, that's not correct.
Okay, when did you hire her?
I believe she first started working for me around December 1st.
December 1st of 2017?
Yeah. Might be the day, it might be just before, just after, but right there. It was not October.
Do you keep records to be able to?
The record.
I will ask that for Mr. Jecevicus, for the record, please let me ask my entire question, and don't try to anticipate my question. Just wait until I ask it so that we have a clean recording, so that me and your attorney are able to listen to the recording when we write our brief. So just wait till I finish the question and then answer. I won't go too fast. It's okay. Take our time. Do you keep records, employment records, that would show when she started working?
Not for a part-time employer.
Okay. So you just said not for a part-time employee. How many hours a week was Jamie scheduled to work when you hired her?
I would say in the kitchen, she probably worked 25 hours a week.
How many days would that be?
I think she would work 4 in the kitchen, and then she had the dishwashing day also. So 5 days.
And what hours would she work when she worked?
I think she usually worked from 2 to 9.
Thank you. Aisha, Mrs. Jecevicus. Can I call her Mrs. Jecevicus?
You should.
Is that fine? Okay.
Sure.
Mrs.
Yes.
Jecevicus manages the restaurant side of the business?
We kind of do both. We both do. We share if need be.
Who does the payroll for your employees?
Aisha
Who runs the payroll?
Aisha does the payroll on a written check. If I'm helping out on a part-time side, I pay.
So it's your testimony that when an employee is part-time, you pay them? You handle those records?
I pay them, yes.
And do you do the scheduling?
The kitchen kind of has the kitchen has the same schedule regardless of who's working, yes.
Okay. Do you have the exhibits in front of you that were entered for this case?
Yours, right?
Yes.
Yep, I got them.
Attorney Lloyd's?
I got them now.
Okay, are you able to identify the little numbers in the right-hand corner?
Yes.
Okay, I want to ask you to turn to ERD C009. Tell me when you're there.
Yep.
Okay. This is the position statement that you entered when you received the complaint that Jamie Lamoreux had filed with the Equal Rights Division. Is that correct?
Yeah, I believe so.
Did you draft this response?
I think with the help of my attorney, we did, yes.
Okay, if you turn to C006, let me know when you're there.
Wait a minute.
Mhm.
Pages are sticking. Okay.
Is it your testimony that your attorney, Larry Lloyd, helped you draft this position statement?
Yes.
Hold on a second. I'm going to interject here. I did not help him draft this particular statement. This was by another attorney before I got on board. I believe Mr.
Oh, you're right.
I can't think of the attorney's name, but it was another attorney before I got on board, so I didn't draft this at all.
Yeah, I'm sorry. Excuse me. This was Jeff Hayes.
Jeff
Who did?
Hayes, could you spell that name?
Hasse. No. Jeff.
What?
I think it's either.
Jeff Hayes' name is spelled, Attorney Hayes is Haase.
Okay.
And I just would say in the future, Mr. Lloyd, that you cannot testify and in dealing with a situation that, in my understanding that you were effectively testifying or rebutting your client's statements, which my understanding is not normally the job of an attorney. So anyway, just if he misstates something in dealing with things, you can follow up on rebuttal. Sir, that one of the things you need to do is to wait in the questions that the recording, if anybody's speaking at the same time, will be all messed up and dealing with the matter. So please try your best not to speak at the same time as somebody else is. I just was addressing not your dealing with the situation, but I just, I had a concern regarding your attorney testifying. So I've stated it. Go ahead with the next question.
Thank you. For clarity, I will ask, an attorney named Jeff Hayes assisted you in preparing this position statement?
Yes, I was mistaken. It was a long time ago.
Okay, just a yes or no answer is just fine.
Yes.
That's all right. That's quite all right. Okay, if you will please turn to C009, just a few pages ahead. And I want to direct your attention to response number 6. Just let me know when you're there.
I'm there.
Okay, so you wrote Jamie was a part-time employee, also that she wanted to be paid in cash on a weekly basis. We had an understanding that she would be paid on Tuesdays. However, there were many times when Jamie Lamoreux would ask to be paid sooner, or she would ask for advances in her salary. And a few sentences down, she was always paid on time, and many times she was paid in advance. And then the final sentence is, she never complained that she was not getting paid. You were involved in drafting that statement?
Yes.
Okay. Now, I would like to turn to the discovery responses that your attorney submitted on your behalf at ERD 058. Just let me know when you're there.
Just, Ms. Archer.
Mm-hmm.
One of the things in the matter is that one of the reasons I go over and so that these are in, my request anyway is that if it is not right now, there is an agreement to foundation, i.e. that it's drafted by the people indicated for the reasons indicated. Those are all admitted. If you want to talk about inconsistencies of the matters, then you do not need him to testify regarding what those things are separate, because they're all in and you can put it in your brief. So if you want to compare these things, and I don't want in the matter of you reading as far as to dealing with the things, I know it's a frequent thing that attorneys do, but the fact is that these exhibits are all in the evidence now. Reading them further or having them say, when it's already agreed that he said these things, that he said them does not add one bit of evidence. Now, if you're viewing that they're still needed, even though if it adds no evidence to the situation, I will be dealing with the matter, but you understand my point?
I do. I was hoping that after we discuss the inconsistencies with the discovery responses, we could look at the text messages and perhaps Mr. Jecevicus could help us sort out why there were so many inconsistencies.
And dealing with it, I mean, the thing is in the matter is that, it just to think about the matter that right now it's all in. Okay, so if you want to go to things that actually be evidence, I'm just asking, please go to what would actually be him testifying rather than them saying that, yes, that's in. Those in the record, there is an agreement on foundation that they are what they appear to be. We don't have a dispute, as far as I understand it, from Mr. Lloyd at all regarding, there is no dispute on the foundation of the text messages or any of these exhibits.
Okay, there are disputes between the parties as to whether there was a weekly payday, as to whether Jamie ever complained about not getting paid. I mean, there are disputes. That's the foundation of their case.
Things, and then please go to what he's testifying regarding the situation rather than basically saying, anyway, I'm him testifying as to what a document says is not him adding any testimony. The document says it's admitted, it's been acknowledged and dealing with, and I just would note that, and that you will have a chance to point out any inconsistencies that you want in the matter in your brief.
Okay.
So if you really need to go over these things which are basically in already, then, I'm saying, I understand that a variety of people do that. I don't quite understand why, but if you feel like there's some need for, my understanding is the purposes of witnesses is for them to provide their own testimony and not to read documents. So anyway, I've made my point. You can decide to what extent that he needs to confirm something that's already acknowledged.
Okay, I understand.
Go ahead.
Thank you for explaining that to me. Can you just give me a moment while I just look over my notes?
Sure.
Thank you. All right, I'm ready to proceed.
There is two things I just simply to note for briefing issues. One is that in dealing with my understanding that there are rules regarding payroll retention. If they are not met in the circumstances, the question is for this hearing as well as to what is the impact of that. As well, that my understanding is that there are certain rules about how employees are supposed to be paid. Again, in the matter, there's a question as to what do I do about that in the situation as far as, in dealing with this major credibility disputes regarding the hours worked, when she was paid, etc. That these are anyway that the extent to which that they're paid in this fashion in the circumstances. Well, there's also, and I just would raise a additional question. I note in the matter that the among the things that are not in evidence is any taxes claimed or what she reported on her taxes. So am I correct, Ms. Haley, that I'm assuming with Archer, that you are not introducing for this matter for evidentiary purposes what she reported on her taxes. Is that correct?
That is correct, Your Honor.
I certainly had a case in which that resolved rather quite quickly, because if she was reporting, the likelihood of her reporting more than she was paid on her taxes approaches zero. But we don't have that as far as what we reported, and we don't have any records and doing the matter. And so as dealing with the briefing, then, what do I do with this dispute that I don't know what he reported, I don't know what she reported, and the dispute on this as to what impact of that have on a probable cause hearing where this is a central issue. So anyway, that's an issue for briefing. It's certainly an issue that I'm going to have to deal with, as well as my understanding is that there was my understanding is that you can refer to, and since it's a statutory or rule thing, the statute regarding record retention regarding payroll. I'm quite sure that there is one. I can't quote it, but in the matter that that is something which my understanding is that I have to deal with in this matter. Would either of you dispute that those are issues that I will have to address?
Your Honor, I think I do. I may be somewhat confused. I mean, the complainant, we're bringing in evidence and arguments regarding when she was paid, not how much she was paid, because it speaks to the conditions of her employment. And we're talking about a constructive discharge. We want to talk about what conditions are tolerable, what people put up with in their workplace, the security you feel in your workplace. Miss Lamoreux never testified that she wasn't paid. Her testimony was that she didn't know when she'd be paid, and certainly the respondent. Oh.
Okay, well, that again, let me try to state it further. You have stated, and it's clearly an issue as to how much she worked, and because obviously that that the questions of how much that she worked and when she was paid, because there are issues for this case. In almost any other case, those would be very simple to resolve because there would be payroll records. There aren't in this case. And there's a direct claim that they were being paid in that way. At least part of the agreement was to avoid, my understanding, in dealing with, again, these are laws that you can refer to that aren't on the statute, that if somebody is an employee, that there is to be withholding and payroll matching. My understanding is that is a law regarding wages, and it has to do with Wisconsin as well. So my understanding is that the parties are both stating we did not comply with that. Okay. Now, and I also, in the matter that the frequent issue in dealing with restaurants and people claiming, and this is not one where people paid tips. My question is always, okay, what did you report? I'm not going to, if a waitress says that back pay should include tips and they don't report it, the tips that they were making previously to the government, I'm not going to award back pay for tips that she didn't acknowledge or he didn't acknowledge. So there is an issue regarding incredibility, and also, when we are entering in the side regarding what to do with credibility issues and other things regarding a matter, dispute over something which, if the law would have been complied with, that we would have records to determine that easily. So I'm saying, what do we do about the fact that there aren't normal records on something that there almost always is normal records about? So is that clear, Ms. Archer, is what and is that also clear, Mr. Lloyd, regarding what I'm raising as far as, do I do anything? Is that, how does that affect credibility or what I do with the situation in this probable cause hearing, regarding the parties' positions in that regard? I am not sure. I haven't directly, I believe, had a hearing on this, and I don't believe that there is any particular case law about this, unless then either you can find that in Wisconsin as to what impact it has on my and how I'm supposed to view the positions taken by the parties. So, Mr. Lloyd, am I clear regarding my question?
Yes, I believe you're clear on what the ask is here. Yes.
Okay, and then I will. All right. So, all right, then go ahead with your next question, Ms. Archer.
Thank you, Your Honor. Mr. Jecevicus, did you pay Jamie weekly on Tuesdays?
Yes, I did. Up to a point, she was getting paid cash. Can I elaborate?
Sure, yes.
Larry, can I elaborate?
I'm the one doing the questioning.
She would.
You may elaborate.
Okay, she would get paid cash. I do my banking on a Monday. So anything that I make in cash goes into the bank, okay? Along with the credit cards and whatnot. If there's a really, really slow Monday, slow Tuesday, she will not be able to get paid her cash that she wanted until a further date. Wednesday, sometimes it would be Thursday. But maybe once it was Friday. Other than that, she was a day or two behind due to the cash not being there. That's why I offered her the right to be put on payroll, and she denied and denied.
Okay, that's past the question.
Well,
Okay, so go ahead to the next question.
Okay, thank you, Your Honor. But on those days when you didn't have the money that you needed to pay her as your employee on Monday, you didn't give her a heads up that she would be paid later in the week. Is that correct?
when she would ask me, yes, I would tell her.
Yes or no question?
Yes.
Yes, your testimony is that yes, you would give her a warning or an advance notice that you weren't going to pay her on Tuesdays as you agreed?
Every time? Maybe not, but yes, I have gave her warnings, yes.
Okay. I would like to turn your attention to, please, and I swear, Your Honor, I'm not going to read it. I just want to turn our attention to C603.
C what, 03?
063.
Okay.
Thank you. Let me know when you're there, Mr. Jecevicus.
C063?
Yes.
I'm there.
Okay. Oh, let me put you to 062. I wrote the number wrong in my notes, the page before. Now, these are discovery responses that you signed under oath, and you say you further deny that any agreement was made to pay on Tuesdays. Can you please explain that for us?
What? Ask me one more time.
Under oath, you wrote in these discovery responses that there was never any agreement that she would be paid on Tuesdays.
So you want me to elaborate on that?
Please.
I guess that was just to determine day due to when everybody else is getting paid. That's when I could try to pay her was Tuesdays because she did not want a payroll check, which is every 2 weeks.
Okay. I would like to now jump forward to some of our text message evidence. Please turn to C126.
Okay.
Okay. Now, this, my understanding is a text between you and Miss Lamoreaux. You say, I know it's payday, I know this. You're referring to it being Tuesday, is that correct?
What page is this again? I'm sorry.
Okay, 126 of the complaint.
Okay.
And the question again?
Your message, Miss Lamoreaux texts you and says, sorry to bother you. Just curious if you're stopping back in here, and you say, I know it's payday. I know this. Are you referring to it being Tuesday?
Yes, that's the date on the text message. Yes, Tuesday.
And when she said, were you going to come down at all? You said, I'm at my son's game. Do you need something urgent? Did you go back and pay her that day?
That's the next page. Do I need something urgent? There, okay. What was your question about that?
Did you pay her on that Tuesday?
I can't tell you if I did. I don't know if I paid her or not, because she must have, because she stopped asking me.
Okay.
I was at my son's basketball game.
Okay, and you had not given her advance notice that you were not going to pay her on Tuesday?
I didn't say I didn't pay her that day.
Okay. Okay, if you can turn to C095, please.